standing in trial or coming to try me is a terrorist. That's what their law says.
Section what, sir? As simple as that.
Section 2, subsection 3F of Terrorism Prevention and Prohibition Act.
The perception that some people believe that because Kanu has committed some crimes, why should anybody fight for him? I'm going to answer it this way. You know Nelson Mandela?
Yes, sir.
He was regarded as a terrorist because he was fighting for the liberation of blacks in South Africa. In fact, Nelson Mandela's name was not removed as a terrorist until he became president of South Africa. That was when the US lifted the terrorism tag, granted him a visa, and he traveled across the world. And one of the things he said when he was visiting the US, same question was asked of him. Why is it that as a person who's freedom loving, you are supporting Cuba? Which the person said, that's a human rights violating regime, referring to Fidel Castro. He said to them, sometimes the problem with you people is that you want to choose our friends for us and you want to choose your enemies for us. That is basically what's happening in your MBA group. Some people are trying to choose your enemies for you. But the question you should ask yourself is, what is Nnamdi Kanu fighting for? Self-determination. It came out several years ago that the Igbos are tired of being treated like slaves in the country. And he wants the former Biafran region to break away as a nation state. The constitution is very clear. You can agitate for self-determination. But we don't have the position of referendum in our constitution. He started peacefully. He was going from village to village. In fact, he didn't go from village to village. He was on a radio. His only weapon was a microphone. Guess what? When he was arrested the first time, what they found on him was a microphone, not a gun. They found with Mandela a pistol. Well, with Nnamdi Kanu, they found a microphone. In fact, when they were asked to present evidence, even in the ongoing case, the evidence presented is that microphone, his underwear, top and bottom, and some of his writings. No element of terrorism was established in court. Nobody has testified that they saw him buying guns or ordering guns or ordering. They brought to court different kinds of audio messages, which was his response to when police was killing his people. When I was at Sowore Reporters, I had in my possession a video which I published at that time. I don't know if Facebook has taken. As the Nigerian army went to where IPOB people were peacefully gathering and shot them dead live. 2014, I think. They killed them right there. This was captured on tape. It was provided by Amnesty International to me. So who committed the crimes? Is it the person who started peacefully or the government who said so? But like I started this with, this was the goal, But the simplest question a lawyer asks when you go to court is evidence, right?
Yes, sir.
If somebody is brought before a court on terrorism charges, and we have not been able to prove it in 4 years, there's something wrong with that process. Meanwhile, Simon Ekpa was arrested maybe last year. He has been convicted within 6 months in Finland. He may not have been as guilty as it, but he has the process of appeal. The trial was speedy, open, and in my own view, fair. What happens to Nnamdi Kanu? You just keep defending, detaining him. Even when the Court of Appeal said that he's discharged and acquitted and wrote that he should be released forthwith, you refuse to honor that court order. And you are going into MBA groups to say, why is anybody fighting? You are taking extra legal steps to violate the right of a campaigner for self-determination. We are taking extra legal steps to force your hand to respect his rights. That is the reason for my protest. And who is in a better position to know a sham trial if it's not Sowore? I've been subjected to as many as 10 of those foolish trials. I have about 3 now pending. And they are going to end up in nothing. That's why since 1992, I don't write statements in police station. They sit me down, we are reading your rights to you, because I know we are not going to trial, for which my statement will be needed. And if I'm going to trial, my statement will not count. The NBA cannot, the American Bar Association sends representative to all my court trials. The Nigerian Bar Association is not in court, even as a friend of the court. You should be there standing up and say, my Lord, can we guide you? This is what the law says. The judge can say, shut up. But you are there. You go to your WhatsApp groups, and you know what they do? They then divide it into Yoruba. The people that are most vocal on Nnamdi, which riles me out, these Yoruba pseudo intellectuals. Sowore, he has committed. Will be sending me videos, and I tell them, I say, if you are tired of Nigeria, if Tinubu was tired of Nigeria 20 years ago and he granted an interview that Nigeria should disintegrate, why should you stop others who understand the same right? To be clear, I don't want Nigeria to break up. I'm a Pan-Africanist. The perception that...
Lajide, let's continue from where you stopped. You said that Nnamdi Kanu, the court was asking him if truly that he has that confidence to defend himself without illegal counsel, and he should make sure that he consult an expatriate in this very case.
They said he should consult criminal law experts before he make his final written submission.
All right.
The judge told him, advised him to do that. Because you want to make your final written submission or no case submission, then they will go with views against evidences of constitution against you, and see which way does it tilt. It's not a sentiment. The governor pronounce judgment accordingly. Unlike if you have used his legal team, they will be engaging the constitutional team on on those points on which they use, which they listed as exhibits. Yeah, they will be cross examination. They will engage their witnesses. The defense will also engage their witnesses in questioning inquiry, and they will also be cross examination. The other thing is not going to take place now. The defense will engage each of the exhibits evidence standard by the Constitutional Council, and they will be going to cross examination of witnesses and everything.
Right, Mr. Olajide, the case has been adjourned to the 4th, 5th, and 6th of November. What do you think will really happen on that very on 4th to 6th? What do you think would likely happen on those days?
What the judge says is that's the day they asked him to. Since he said
He has no case to answer.
he has submitted orally. It's not by orally, you must put it to written submission. You know, his defense team after Constitutional Council finished the prosecution of the case. The defense team also said there's no case to answer. They also put there no case to answer into written submission to the court. We can now have two written yes before them. Based on this, no case. Constitution said this. The court said no, you have a case to answer. Some people actually have been established against you. Come and open your defense. So that means they already court, that's one thing already working against Nnamdi Kanu. Court has established that there's already a prima facie established against you. You have a case to answer. Defend yourself on this. Supposing there was no prima facie, they would have discharged him and acquitted. As at the point the judgment came that open defense, what would have come out would have been no based on no case submission by the defense team. What would have just said based on no case submission by the defense team, yes, the court agree with you, hereby discharged and acquitted, you work out freely. The court did not say so. God said prima facie have been established against you, that you have case to answer. Come and defend yourself against this matter. So what will happen on that day is that the court will receive the submission, written submission or written submission by Nnamdi Kanu from him. Court will now fix a date of judgment.
Mr. Olajide, don't you think that what is playing out with Nnamdi Kanu does not really speak well or represent Nigeria's image in the international community?
I don't agree with that.
All right, Netwoko, the senator representing one of the senators from Delta State, actually came out and said that arresting of Nnamdi Kanu is unjustifiable and detaining him in DSS custody. And also, Professor Wole Soyinka also led a voice to it and said that detaining of Nnamdi Kanu is unjustifiable. Perhaps that Muhammadu Buhari kidnapped Nnamdi. He used the word kidnap Nnamdi Kanu. That Buhari then is used of kidnapping people. Do you think that these very two notable Nigerians speaking in favor of Nnamdi Kanu will really represent Nigeria's image outside Nigeria?
You see, my personal position is different from what Nigerian government is doing. It's a pity if you check other platforms are spoken. My personal position has stated this severally. But let us talk of what is now the issue, because it's not a legal matter now. I won't talk about my personal position. I'm talking of legal status of that matter now. Legal status of that matter is that government has gone from High Court to Court of Appeal to Supreme Court.
And the Supreme Court also give, the Court of Appeal also give judgment that Nnamdi Kanu has no case to answer.
Even the Supreme Court, did you know that? Did you know that? Yes or no? Did you know that?
I'm fully aware of that.
Let me educate you if you don't know. I Court of Appeal, because Court of Appeal said you didn't have any case to answer. But when you go to Supreme Court said no. That the matter, the allegation leveled against him, he must be tried on his merits. The Supreme Court said, actually, the issue of how he was born to Nigeria is a matter of irregularities. That's what the Supreme Court said.
And that is the best of what Nnamdi Kanu is standing on. That the Supreme Court have made pronounced. I'm coming, Mr. Olajide, so that.
Let me land my point.
Mr. Olajide, base his argument on that very Supreme Court pronouncement.
You are giving false or half-baked information to the public.
All right.
You are giving false or half-baked information to the public. Renewable settlement, renewable settlement for this matter. I get my point. Put the facts and all the matter to the public.
All right. What is the fact?
That's the fact of the matter you must speak. If you want to go on settlements, you won't like the idea.
Mr. Olajide, what is the fact?
You won't like the discussion any more longer. You'll be interested in it. I'm trying to. If I've told you my own position, personal position, go check on that platform. See my personal position on this matter. I'm not even you belong. I'm telling you what the current status of the law says. Supreme Court judgment says, yes, the problem by which you have brought to discovery is irregularities. It's not what people have said. The allegation made against you at the trial court must be determined on its merits and pronouncement of the court as whether you are guilty or not on that matter must be established first. That must not be the way you are brought to the country must not replace the allegation against you that matter must be tried and you are either found guilty or not. If you are found guilty, well, if you are not found guilty, you are acquitted. But on the issue of how you are going to court, Supreme Court also admitted that it's a matter of irregularities. But it's not a replacement of or a cancellation of that allegation, that charges that's hanging on your neck in the court in the High Court. So therefore, let the case go for the trial. Go and do your check. So forget sentiment, forget ethnicity. So Supreme Court was admitted that yes, process of bringing you to country is irregularity. But charges are already prepared against you. Let those charges against you. Let there be trial of those charges against you. Let the court make a pronouncement whether you are guilty of it or not. You can soon comment of how you are brought into the country. The court has established that yes, it's an irregularity, it's wrong. But the court is saying that does not replace the charges on your neck. So you can take up how you are brought to the public, to Nigeria. You can file a suit against government on that. That was because it's the interpretation of what they said. But the one they are preparing against you, go and answer, prove your innocence on that one first. Let there be court pronouncement whether you are guilty or not on that.
Mr. Olajide, Nnamdi Kanu actually jump bail.
We are now coming to, maybe you want to come to my own personal position on this now. So now, no.
Did he jump bail?
See, when Kanu started this matter, he has a right to self-determination.